want to introduce to you Meade Snyder. He's the lead-off batter here. Meade is a partner with his father, Jim Snyder, in Clifton Forge. I went to law school. I think Jim's a year older than I am. I'm going to say that anyway. He's not here to deny it, but he and I went to law school together at the University of Virginia. And but the two of them mainly practice estate law. And they do wills and powers of attorney and all that sort of thing. So do a lot of the lawyers in the area. But the Snyders have done more in that area, I think, than any of the local lawyers. And so for that reason, I've asked Meade to lead off, because that's a big topic for all of us. One thing I might mention is that, and somebody suggested this to me the other day, as you approach older age, let's say, and you think about what's going to happen if your spouse predeceases you, there is much merit in sitting down with your spouse and talking about how things are going to work. I mean, I know that sounds morbid, but that's very important. You know, do you have a will? Do you have a power of attorney? And Meade will talk to you about a lot of that. But in my own family, my wife's father died. They probated a will that was not the real will. And they didn't find out about it till, you know, down the road. And he had written out his obituary. They didn't find that until after the funeral. So those things are important. And sit down and talk about where your document, do you have the documents? If you do, where are they? You know, and who's going to find them if something happens to you? All those things are very, very important. So, Meade, I was doing a little filibustering there, but didn't mean to take your time. If you'll get up here and tell us about wills and powers of attorney and all that stuff.
All right. Thank you, Bill. All right. I think Bill brought out a good point. You know, estate documents, estate planning is, in reality, planning for your decline in health, potential infirmity, and ultimately death. And that's not something everybody likes to sit down and concentrate on and put focus on and get done. You know, oftentimes folks, for whatever reason, will be something that's put off. Or, you know, if it is done, you know, you run into situations like Bill just mentioned, where maybe the next generation doesn't know where the documents are or who's named in the documents. So I'm going to talk to you today about kind of two phases. One is just the basic estate planning documents that is recommended that you have. And then also on the planning side, because it is two pieces, you know, it's having the right documents, but it's also making sure that they work the way you want them to. So with that, I'll just kind of run through the basic estate planning documents. Obviously, the kind of primary one is a will. And what a will does, it disposes of your property at your death. It has no effect until your death. It's something that you can change at any time as long as you're able and have the capacity to do that. Now, a lot of times folks don't have wills. Virginia does have laws of descent and distribution that governs what happens to your property when you die without a will. And, you know, folks oftentimes come in, they're worried that, you know, if I die without a will, the state is going to end up with everything. Well, the state can end up with things, but they're basically the last in line. So you'd have to die essentially without a relative on the face of the earth before Virginia steps in. But the state's intestacy laws basically try to contemplate what Virginia thinks you would want to have happen. So if you die without a will, married, all your children are with your spouse inherits everything. And then if you're not survived by a spouse, then to your kids. So there are some backstop protections, but it is almost always better to have a will, and I'm going to tell you why. With a will that enables you to do a number of things that you don't get under the intestacy regime. First of all, if you've got specific bequests, you've got certain things you want to go to certain people or organizations. If you want to make a charitable donation to the Dabney Lancaster Educational Foundation or your church, that needs to be done in the form of a specific bequest in your will. You may have certain family members you want to benefit with a specific sum of money, and then provide residuary benefit to the larger class, like your children. So specific bequests. You can also, Virginia does provide now for what's colloquially referred to as the Pots and Pans Act. So we can make a reference in your will that you may leave a separate list or memorandum of tangible personal property. So anything you can reach out and touch. Jewelry, guns, tools, furniture. And what you can do on this list is you can add to it at any time. So you don't have to come back and pay an attorney to change your will. You can change it any time. So if you put Johnny gets the kitchen table and 2 years down the road you get mad at Johnny, scratch it off. But you can add to it. So for household contents, things of that nature, it's a really effective way to dispose of that because you can do it on your own terms. And it's something that we suggest if you have that sort of provision in your will. There are forms that you use for this, and basically just keep the blank forms at home, and as you fill them out, put them with your original will. That way, everything is there, and your executor will have it and know to distribute those items to those folks. So as long as you haven't made a specific bequest for any of those items, your executor will be charged with distributing those items to those folks. The other thing with the will that folks oftentimes come in and they have a list of their assets, their belongings, and their beneficiaries, and they want to, who gets. Oftentimes, it ends up being more dealt with in the form of a residuary bequest. Kind of the typical happy families will, I love you will, is, I leave all my real and personal estate to my spouse if my spouse survives me. And then if my spouse does not survive me, then in equal shares to my children who survive. And you can provide, so the residuary bequest, you don't have to specifically name everything you own, but that all-encompassing language will dispose effectively of those assets according to the shares that you determine. So residuary bequests are very important, and also providing for succession. So if a child does not survive you, does their share vanish and go spread out to the other children that do survive you, or would you want the grandkids to inherit that share? So you can make provision for that. The other thing you can do with the will, if you've got, oftentimes this comes up maybe with a family member, a child, a grandchild that you do not want to inherit. Folks, you can exclude people in your will. And there are certain rights for minor children and spouses, but sometimes there are situations, maybe you've given to one child during life, maybe they've just not turned out quite the way you thought, but you can make exclusionary provisions in the will. The other things you can do with the will, designate who's going to serve as your executor. Oftentimes in the the I love you will scenario, it's spouse is the primary executor, and then one or more children is an alternate executor. Your executor is the person that will be in charge of administering your estate, and that's a process that involves transferring assets that may be in your name, paying estate administration expenses, and then ultimately making distribution to your beneficiaries. So it's That person needs to be someone that's, mature and good with handling money. And you can name more than one executor. Oftentimes if it's at the child level, you may have more than one child that you would name as co-executors. Obviously, if you do that, they need to get along well, or it could be a long administration process. The other thing in your will, you can provide either statutory fiduciary powers or certain powers to your executor that will enable them to deal with your property, such as the power of sale over real estate, which can be an important thing. Sometimes if you have a large family and the kids have all moved away, and it may be a scenario where after you're gone, the house needs to be sold. Well, rather than 10 kids inheriting that house and deciding what to do with it, you can grant your executor power of sale over that so it can be sold efficiently by that executor and then distributed as part of your estate. Also in your will, you can waive surety. Surety is something that usually is required unless it's waived. And what that means is you have to have an insurance bond, or the executor would have to have that when they qualify at the courthouse to become your executor. So, usually if you have a trustworthy person that you're naming as executor, typically you will waive that surety requirement because it will save expense to your estate. Also in your will, and wills are not just for seniors, wills are for everyone. You can name, if you have minor kids, you can name a guardian of the person, of your children. So, you go out on a family vacation, something happens to mom and dad, you can name, whether it's a family member or friend, the person who will have the physical custody in charge of raising your kids. So that's certainly an important provision. And then also within the will, you can provide for kind of special needs situations. If you have a large estate and you have potentially young beneficiaries that may come into play, you do not probably want to have a 10-year-old or in Virginia, of course, you have to be 18 to own property, but you don't want a young person maybe dealing with a large inheritance too early before they're ready for it. So you can provide either a custodial arrangement where you can name someone to manage it for them as a custodian, or you can provide a trust arrangement where you can designate someone to manage the money until they reach a certain age, and that money can be used for their benefit, typically for health support, maintenance, and education. So it can be used to pay for a college education, et cetera. And then the key is, what age are you going to have that money distributed outright? Sometimes we'll see age 21, 25 is pretty typical. I've done a few wills where folks have ratcheted it up there to like in the 50s and 60s. So it's all kind of depends on the situation, and that kind of evolves out of the process of you sitting down and talking with an attorney about the specific needs that you have and of your family and the person that you're trying to provide for. With a will, I strongly recommend that you seek the counsel of an attorney in preparing that. There's a couple types of wills in Virginia. Typically, the witnessed will is a typewritten will where you would sign. It's witnessed by at least 2 witnesses. Oftentimes, it may be notarized as well. And then Virginia does still provide for holographic wills, which is a will that you write out entirely in your handwriting and you sign. And again, just with some of the things I'll mention later, it's generally advised that you do seek the advice of an attorney in preparing a will. So that pretty well covers kind of the advantages of a will. And when folks come in to see us about wills, we always discuss kind of the other essential estate planning documents, and those are a general power of attorney and an advanced medical directive. So a general power of attorney is a document where you can name someone to handle your business affairs, whether it's paying bills, dealing with the rental property, dealing with any manner of things, including, filing tax returns. And the intent is if something happens to you short of death, if you're in an auto accident or just old age and infirmity sets in, you've got someone there that you name, that you trust, that will manage your affairs for you. And Mr. Mabry is going to talk a little bit later today about what the process you have to go through if you don't have a power of attorney in place. Now, a lot of times we see folks will try to address kind of planning for decline in health by putting maybe one of their kids' names on their bank account. Then that child can take care of paying their bills. Well, a lot of times what you run into with that is, the bank, when that account is set up, oftentimes the right of survivorship box gets checked, with survivorship or without. So if you intend your estate to go equally among your kids at that point, after you and your spouse are gone, that signature card is going to control. So what's left in that account will go to that child. So it may not be what you intended. And then the other thing is having someone as a signatory on a bank account is limited to being able to write checks. Can't file tax returns. If something comes up where a piece of property has to be sold, they can't deal with that. A general power of attorney is a much more broad document and is certainly highly recommended. Now with it, you grant very broad power to the person you name as agent, so you have to have complete confidence in their ability and their loyalty to carry out your affairs as you would wish. So general power of attorney covers the business decisions, and then advanced medical directives cover healthcare oriented needs. So with an advanced medical directive, it's typically a couple things in one. Part one is a living will, often, which has nothing to do with property. It's a direction from you to your doctor that if you develop a terminal condition, and it only applies in a terminal condition, you're telling your doctor that you want pain relief and you want comfort care, but you do not want to have your life artificially prolonged. And then the balance of that document is essentially a medical power of attorney where you name someone that can make your medical decisions if you become incapacitated and can't do that yourself. So definitely, and you can name, and typically we'll do, a few folks. So you may name a spouse first, then child A, child B in succession. And typically the document will include the contact information. So if you get rushed to a hospital, as long as your doctor has that document, then they know who to call. So those are kind of the three pillars of the estate planning documents. The other thing I mentioned a little bit earlier, trusts, sometimes those can either be worked into a will if there's a special situation like a disabled child, a young child. Also on occasion there are also standalone trusts, and it all kind of depends on your particular situation. So that pretty well covers the documents, and in the little bit of time I've got left, I want to run through briefly kind of the planning side. So say you come and you put in all of these documents in place. Things you need to consider from a planning side. While you're living, obviously stuff happens. Life changes. You've got wills maybe you did 20 years ago. You probably ought to take them out and look at them and make sure they're still set up the way you want. Oftentimes if you do wills when you're young, you may name a spouse as your executor and another family member, an adult, as an alternate executor, but maybe your kids are grown now and you would want your kids to be the alternate executor. you know, death in the family, you know, significant changes in your assets. All these things can kind of impact your estate plan. So it's something you need to revisit from time to time. Also keep in mind your will is going to control and dispose of assets that are in your name alone, your probate estate. A lot of times, husband and wife own property, their bank account, their house is, you know, tenants by entirety with right of survivorship. You own them as husband and wife with survivorship. Those things pass by survivorship designation automatically. So the will is going to control that piece of property or asset in your name alone. So oftentimes with the I love you will scenario, it becomes more effective, the will, you know, at the second spouse's death. Beneficiary designations, you know, to be attentive of those as well. Oftentimes it may be more efficient to have individuals named as beneficiaries, particularly of retirement-based plans, sometimes life insurance as well. But if you're a young family and you've got young kids, you know, it may be prudent to have on that $1 million life insurance policy your spouse is a primary beneficiary, but perhaps your estate that has that trust provision for your kids as a contingent beneficiary, so that the money flows to the trust rather than outside of your will. So all these things impact the success of your planning, is how I'd put it. Also, you know, with fiduciaries, your executor or trustee or guardian that you name, if there's any change in those folks, if they move out of the area and just aren't going to be accessible, they pass away, obviously you need to be attentive to updating your documents as needed. We've talked a little bit about using trust either in a will or outside of a will to provide for young beneficiaries, beneficiaries with special needs. You know, sometimes it comes up in a creditor protection scenario. Maybe you've got a child that has creditor issues or potential divorce issues. You can protect their inheritance through the use of a trust mechanism. So that's something to consider as well. The other area that comes up quite a lot, we get questions about, you know, folks are worried about either the state ending up with all the money or the federal government and all going in taxes. And the other is the in-laws, you know, if the in-laws will end up with everything. But so everyone's probably heard about the estate tax, the death tax as it's sometimes called. As of the most recent tax act that was passed under the Trump administration, you should each be glad to know that you each can pass $11.4 million this year by gift or inheritance to your beneficiaries. So $22.8 million for a husband and wife. So that hopefully adequately covers everyone here. That's the death tax, that kind of elevated rate. So that was one aspect of the recent tax act. It elevated the rates or the exclusions to $11.4 million for this year per person. So lifetime gifts and testamentary transfers. That law does have a sunset provision. So if by December 31, 2025, if Congress does not act to extend it at that level, then it's set to roll back to a base $5 million exemption per person, but it's indexed for inflation, which at this year would put it, without the recent change, at about $5.7 million. So between husband and wife, that still covers quite a bit. Also, estate tax related, just something to keep in mind if you do have a larger estate where that may be an issue. With some of the more recent changes, The exemptions or exclusions have become portable, so they've tried to simplify things. So if wife dies first and she's got $5 million, doesn't use all the 11.4, husband can file an estate tax return to pick up that extra money and carry it forward for his benefit. Okay, so that covers estate taxes, again, which is really effectively not an issue for most folks. The other thing I want to talk about is, what happens when there is a death. As Bill mentioned earlier, finding the last will and testament is an important thing to do. And there is only one original will that needs to be kept in a safe place. We always recommend, that could be either firebox safe at your home, safe deposit box. If you keep it in a safe deposit box at your bank, you may want to think about having your executor or alternate executor having their name on the account. That way they'll be able to easily go in and get it when needed. You need to talk to your family members, particularly the ones that you've designated as your fiduciaries, about your documents, where they are, so that when the time comes, they'll be able to find them and administer them and carry out the wishes that you've put in place. So locating the will, once you've done that, you do not need to rush right down to the courthouse with the will. What you first need to do, and what the clerk of court will need to know, is a little bit more information about the estate. So you'll need to know, and this is more for your executor, they will need to know, roughly the value of the assets passing under your will. Again, assets in your name alone. And they'll also need to know your names, addresses, et cetera, for all your heirs at law, the people that would inherit if you did not have a will. The clerk of court will need all that information. So kind of once you've got all that in hand, that's going to determine whether you have a one-step process or a two-step process at the courthouse. If there's a will, step one is just admitting the will to probate. So that's a fancy word for just putting the will to record in the jurisdiction in which you died. Now, the person that you named as your executor may or may not need to do step two, which is to qualify as your executor. Oftentimes, husband and wife, with a lot of right of survivorship assets, there may not be enough assets in the first spouse's name alone to justify that surviving spouse to qualify as your executor. And there is a procedure that you can go through for smaller estates through the small estate affidavit procedure to effectuate transfers when there has not been a qualification. So again, step two, if the executor does need to actually qualify, the clerk of court in Allegheny County, currently Debbie Byer, her office handles that process and will grant administration to the named executor. And what that does, once the qualification has taken place, that kind of clothes the executor with the official power of the court to serve as executor. And with that, they'll be able to deal with the assets in the spouse's or in your name, such as bank accounts, so they can go to the bank, close a bank account. They'll need to set up an estate checking account to administer the estate. They'll have to get a tax ID number for the estate and file potentially income tax returns for the estate. So there's a lot that can be involved with an administration. But that is just kind of a nutshell of the process. And just a couple quick takeaways as my time is starting to run out here. Again, going back to what Bill said before, it's always best if you can be prepared, get your documents in order, and let your family members that need to know about that know where they are and so they'll know what to do to carry out your wishes. And the other takeaway I will leave with you is just beware of trying to do things by self-help. You know, the internet is a wonderful thing, but it also is grounds for, you know, it's a place where you can find form wills, you know, fill in the blanks. Those things, you know, in certain situations they may work, but I've seen a lot of them that don't have the intended consequence and result that you would have desired. So it really is prudent to get your affairs in order and consult with the Virginia attorney to help you with that process. So, all right. That's all I have.